And we're joined by Daniel Bwala, who is an adjunct lecturer of Nigerian Law School, Abuja. Thank you for joining us this morning. Well, for many, while they wait on the reasons why the Supreme Court gave this judgment, for some who speak about the card readers, they just wonder, does this or is this discouraging the use of card readers? I mean, this speaks directly to it. What do you think about it?
Well, thank you for having me. I am not surprised with the judgment of the Supreme Court, especially in relation to the card reader, because the Supreme Court had already given a judgment in Shinkafi versus Bialy's case, and the Supreme Court suggested that the use of card reader is vital. However, it's not the only way by which you can adjudge the propriety or otherwise of an election. The Supreme Court stated clearly that the card reader and the register of voters are to be carried along. So if a court gives a decision upholding the card reader and jettisoning the other aspect, the register of voter, then obviously the judgment of that court will be ruled in error.
And then you also spoke about the fact that you also spoke or addressed the issue of doctrine of necessity. What did you mean by that?
Right. Well, the doctrine of necessity is the application of the law, having regard to the circumstances of the case. And we have seen in 2015 how the courts, both from the tribunal level to Court of Appeal and the Supreme Court, are applying that principle in curing what ordinarily would have been a defect. For instance, when in Rivers, a motion was filed challenging the jurisdiction of the tribunal sitting in Abuja instead of Port Harcourt. Well, the tribunal, as well as the Court of Appeal, and right up to the Supreme Court, they held that looking at the necessity of the situation, it was imperative that the tribunal could sit in Abuja. So that's one example of the application of the doctrine of necessity.
Will people be wrong if they interpret this judgment, at least maybe before they get to see the reasons, that, well, maybe now we shouldn't pay a lot of attention on the card readers, or if we're to pay attention to the card readers, how should they approach it?
Well, it's important to have a broader perspective of the case and the decision of the Supreme Court. Card reader is not the only reason upon which the Supreme Court overruled the decision of the tribunal and the Court of Appeal. Don't forget that the petitioners at the tribunal, when they filed that action, principally their petition hinged on irregularity, violence, non-compliance with the provisions of the Electoral Act as provided in Section 138, subsection 1B. And then also you look at Section 139.
No, you have said that.
So if I have to put it this way, let me say that, all right, go ahead.
No, conclude your thoughts.
Finish your thoughts, please.
All right. I'm saying that, for example, if you look at the case in Rivers State, the tribunal rejected about 100 pages of document in support of the petition of the petitioner. That's one side. And then number two, the tribunal upheld the use of card reader and decided that unless and those results from the product of card reader were the ones that were valid, the tribunal also accepted in evidence the testimony of an INEC officer who was not himself present at the time of the voting and who tendered document that can be considered in law as documentary hearsay. So there are quite a number of issues that were observed by the tribunal. And when the Court of Appeal upheld the decision of that tribunal, it was still on the basis that the petitioner could not prove his case, or rather the respondent, that the petitioner proved his case, proof his case in the case that there was no election. So, but the Supreme Court in her judgment expressed concern about the tribunal's obvious, refusal to consider the document that were presented before it. The tribunal also holding that there were violence, there was non-election. And don't forget that the electoral also provides that if you have to prove an electoral offense, one of the ways you can do that is except and unless the offense was committed within 300-meter radius or circumference of the polling unit. it will not have the effect of law to invalidate the result of that election. So if there was a violence 500 meters away from the polling unit, it is not enough to establish non-compliance. The other aspect is the element you have to prove when you are making an argument that there is a malpractice, irregularity, or non-compliance. For example, the Supreme Court has held in several cases that if you want to establish non-compliance, it is an onerous task. You have to establish that there is no compliance with the provision of the Electoral Act to the extent that the court would arrive at a judgment that your case is proven. When you do that, then the respondent will have to now show that the non-compliance is not substantial to invalidate the election. If you raise the issue of irregularity, then you must establish that there was an irregularity and that irregularity could be linked to the winner of that election and or he authorized that irregularity. If you fail to do that, you have not established your case. If you raise the issue of malpractice, then you have to establish the existence of the element of that offense. For example, if you're raising malpractice, you're obviously saying there is probably a false result. You have to establish that beyond the shadow of that, beyond reasonable doubt, because it's a criminal offense. And Section 138 sub 1 of the Evidence Act provides that where a commission of an offense by a party to a proceeding is directly in issue, then it doesn't matter whether it is civil or criminal action, that element must be proved beyond reasonable doubt.
And it would seem that for you, these are the elements that make the judgment not come as a surprise. But what did you make of the arguments on the other side before this judgment was given?
Right. The other argument on the petitioner side could also be valid in law, because we are all witnesses to the fact that in the country, the build-up to the election, during the election, and the aftermath of the election was obviously marred by violence. There was boycott by a section of APC members. And then because of the violence and some of the situation, international community also condemned the act and the conduct of that election. So if we look at it from the perspective of the people, then we could agree that the tribunal was right to have nullified the election of Governor Wike. However, in law, you don't establish your case by media report or newspaper. Even if you have a valid petition, if you fail to prove your petition, the court is not Father Christmas. The court cannot give you what you did not present to it. The other thing is, even if you provide all the evidence and table it before the doorstep of the court, if you do not prove the documents before the court is not an investigator. The court is an adjudicator. So you do your investigation, you do your argument. If it is cogent, credible, and compelling, then you have the relief you seek for in law. And it appeared that in the case of Rivers, that was not established right off the cuff. So I'm not surprised with the decision of the Supreme Court.
The thing here is about the provision talking about the distance, the 500 meters from the place of actual voting to the place where maybe violence occurred. Isn't that a given that it is already there in the statutes for maybe the counsel of the petitioner to understand that perhaps I've not been able to establish where there was actual violence in some of those polling booths or units?
Right. 138, Section 138 sub 1B of the Electoral Act also says that, it's a ground you can have the election nullified if you can show there is non-compliance with the provision of the Act. And then you can give an expanded interpretation of non-compliance to incorporate issues like irregularity, like violence, ballot stuffing, even bribery. If you look at Section 117, I think, of the Electoral Act, you see in an elaborate terms electoral offenses. Now, whether you bribe someone, you try to convince someone, whatever you do, if it is outside of the 300-meter radius or circumference of the polling unit, then it will be difficult for you to be able to prove that that violence or whatever non-compliance is substantial enough to affect the outcome of the election. And don't forget also that even when you have proven that there is irregularity in a polling unit or in a ward, before you can get the judgment delivered in your in your favor, you must fulfill the condition in section 139 of the Electoral Act that the non-compliance is substantial enough to affect the outcome of the election. So if it is not substantial enough, you cannot have that. We have decisions of the Supreme Court in respect of that. Buhari, Obasanjo,